Hi, and welcome back. Today we will talk for a moment about the purpose and elements of a contract, Chapter 11 and Chapter 12. I will speak specifically about the element of agreement in contracts on the next video after this. But first, contracts exist to make business matters more predictable. In order to have a valid contract, we must have all of its necessary elements. They are agreement or valid offer and acceptance. The element of agreement is that one party must make a valid offer and the other party must accept it. Then consideration. There has to be bargaining that leads to an exchange between the parties. There must be consideration. Consideration is the glue of contracts. It has to be present in order to make the contract stick. You will hear it called the bargain for exchange. This means each party must receive both a benefit and a detriment from the contract transaction. There's legality. The agreement must be for a lawful purpose. This means that the agreement terms cannot violate laws or statutes. Both parties must have the legal capacity to enter into a contract. Generally, this is understood to mean that the parties must be adults of sound mind, but minors, those persons under the age of 18, can enter into contracts as well, and we will talk more about that later. Writing. Some contracts are also required to be written, but there are many exceptions to this rule, and we will get into that as well. Let's talk a little about the sources of contract law. Common law is the law we look to when we are dealing with contracts for services, employment contracts, marriage contracts, and real estate. Then a set of legal guidelines that is called the Uniform Commercial Code is what is used by businesses, judges, and lawyers when handling disputes about contracts dealing with goods in an amount greater than $500. Specifically, Article 2 of the Uniform Commercial Code, UCC, governs contracts for the sale of goods. Goods means anything movable except for money, securities, and certain legal rights. But what if a contract has both goods and services? Say, for instance, when you hire a painting company to paint your house, but they also furnish the paint as well. This situation is a mixed contract. Here, courts will apply the predominant purpose rule. The predominant purpose rule says that we look at what the predominant purpose of the contract was. Was it to paint the house, a service, or to furnish the paint, a good? We look to see what the main purpose was of the contract, and if the main purpose was to provide a service, then common law will govern how we settle any dispute about the contract. If the main purpose of the contract was to furnish goods, then we look to the UCC for guidance. That's very important, especially in test taking. Goods or service. Then you know which rule to apply. Let's talk about the different ways to describe contracts. Your book calls this the types of contracts. Okay, these are the bilateral contract, where two promises are exchanged. For example, if you agree to cut my grass this summer, I agree to pay you $10 each week. I agree to pay you $10 each week. We are exchanging promises to do things in the future. A unilateral contract is the exchange of a promise for an action. For example, I will pay you $1,000 if you bring my car from Charlotte to Raleigh. I will pay you upon receipt of my car. The act of bringing the car is acceptance of the contract. Until the act is accomplished, the contract has not been accepted. An express contract is one that has all the essential and important terms spelled out. An express contract can either be in writing or it can be verbal. An implied contract is one where the parties' actions make it look as if, or it can be implied that the parties had an agreement. Say, for instance, you go to the barbershop every week to get your hair trimmed, and you always make payment by sending a check in the mail. Every week you just go sit in the barber chair, the barber cuts your hair without saying a word about payment. This is an implied contract. An executory contract is a contract that has not yet been fully performed by both parties. There are some additional obligations that were promised that need to be performed or fulfilled. An executed contract is just the opposite. It is a contract that has been fully performed by both parties. There are no obligations that need to be fulfilled. It is fully performed. Lastly, valid contracts are those contracts that contain all the elements necessary for a contract: agreement, consideration, capacity, and if needed, a writing. An unenforceable contract is one that is missing one or more of these elements. Avoidable one is one that is entered into by a party who does not have the legal capacity to enter into the contract, like a minor or someone who is not of sound mind or to understand the contract. This doesn't mean that these types of persons cannot enter into contracts. It just means that they can enter into contracts if they wish. It just means that they have the option to disaffirm the contract and step out of the contract. Lastly, a void contract is a contract that is not valid because the law says it's not valid. In our next video, we will talk about the first element of contracts. So stay tuned.